This is a long article from the implementing regulation of Chinese trademark law. It is a further explanation to the aforesaid articles. In the first item, it has mentioned which documents shall be required when you file an opposition, such as the application form and some evidence materials and power of attorney. In the second item, it has given both the opponent and the opposed party about the right to reply for opposition within 30 days. This time limit is also not extendable. However, if the opposed party has failed to make a reply to the opposition filed by the opponent, it does not mean he has lost the right, but it won't affect the examination of the trademark office. Another article from implementing regulation. For this article, it has set forth a detailed requirement about opposition. Also, I would like to draw your attention to this item. Is a time limit for the application for review and adjudication. It shall be calculated from the date of publication of the adjudication of the trademark office. Okay, for the cases. The first case, the opponent is president and fellows of Harvard College on behalf of the Harvard University, and the opposed mark is Harvard in Chinese characters. It is a transliteration to the Harvard. The background of this case is that a Chinese company in Shanghai has applied for a Chinese character as Harvard as a trademark on the goods of medicines for human purposes and relating goods in Class 5. And as you know, Harvard is very famous is very famous among the Chinese consumers, since the Harvard University is one of the most famous universities in the world, and it has long history. I remember it was founded in 1639. So most Chinese people are familiar with Harvard University, namely its Chinese name, Harvard Daxue. So the president and fellows of Harvard College, on behalf of Harvard University, has filed an opposition with the trademark office against this Chinese mark Harvard. However, Harvard University has not registered his mark, both Harvard and Harvard in Chinese, in Class 5, on the goods of medicine. But however, since the Harvard is a very famous name on behalf of Harvard University, so the opponent, Harvard University, deems that if the opposed mark Harvard is approved for registration, it will damage the legal right of the Harvard University and may cause confusion among the Chinese consumers. So he filed an opposition against this mark, but the opponent, but the opposed party claimed that since Harvard University has not registered its mark in Class 5 on the goods of medicines, so the Harvard University has no priori right in this class, so the mark Harvard in Chinese will not damage the legal right of Harvard University. Now this case has received a decision from the China Trademark Office. The outcome is the approval of the opposed mark will cause confusion among consumers due to the claim of Harvard University, so it shall not be approved for registration. The China Trademark Office has made such decision based on that the Harvard University is very famous, and is marked Harvard and Harvard in Chinese, well known among Chinese consumers. So once the postmark is approved for registration, it will indeed damage the legal right of Harvard University, and may also bring confusion among the consumers. So the Trademark Office has rejected this mark. The second case, the opponent is the Apple Incorporation, and the opposed mark is the Apple logo with the English word Apple. Also, the Apple Incorporation has registered many his marks in China, like the Apple logo and English word Apple as his marks in China. The background of this case is that one of the Shanghai company has applied for the postmark, the Apple logo with the English word Apple, in the services of communications by computer terminals or the cell phone communications and relating services in class 38. And Apple Apple Incorporation has also registered his mark on this class on the services of communications by computer terminals or cell phone communications. So the Apple Incorporation found this postmark in the Trademark Gazette. So he filed an opposition with the Trademark Office. The basic grounds of Apple Incorporation is that the postmark is composed of Apple logo and the English word Apple, which is similar or identical with his mark, Apple logo and Apple. So it will indeed cause confusion among the consumers. But the outcome of this case is that the postmark has constituted similar mark to the opponent's mark on the identical or similar services, so it should not be approved for registration. From this case, we could see if one company or citizen individual has applied or registered his mark prior to the postmark, he has a priori right, and he could file an opposition to the postmark based on his priori right. And the Trademark Office will examine the case based on both two-party settlements and materials. The Trademark Office will consider the priori right of the opponent and both whether the postmark has been filed on bad faith. In this case, I think the postmark, the Apple logo with the Apple English word may be filed with the bad faith. So the China Trademark Office has rejected, and the Apple Incorporation has protected its mark in this class and to prevent the confusion among the Chinese consumers. Okay, that's all for my presentation today.